Well, the state's Freedom of Information law came under scrutiny in the special session called earlier this year by Governor Sarah Sanders. An outgrowth of the pushback to proposed changes has led to a broad and diverse coalition of political allies pulling together to put the law into the Constitution and into state statute. Attorney Jen Standerfer and Senator Clarke Tucker joined me for a conversation. One of the things that's interesting to me is there will be a constitutional amendment proposal and there will be an initiated act proposal. I don't think a lot of people understand or know that. Explain to me why that is.
So we tried to do it all in one document. We tried really, really hard. we had a lot of smart lawyers in a room who thought we can figure this out, and we could not. And the issue is really just that the way our law is set up. You know, we have the Constitution, and then we have our statutes, and then we have everything else. And when you muddy that together and start talking about each other in the same documents, you create all sorts of problems with the separation of powers and the supremacy clause. And so finally, we sat down and looked at it and figured out that if we just do it the right way and change the Constitution in the Constitution and change state law with an act, then we fix all those problems.
Yeah, we've seen a lot of proposed constitutional amendments that cram a lot of descriptive language into them. They usually go down in flames.
Right. Yes.
But I mean, obviously, this was kind of a breakthrough moment when you guys decided to do it this way. Was that going to complicate things, do you think? I mean, will people understand that they're voting on two different issues that are linked?
I think so. One is the constitutional amendment is named the Arkansas Government Transparency Amendment, and the initiated act is going to be named the Arkansas Government Transparency Act. Really, the complicating factor is that you have to gather signatures for two measures instead of one. Obviously, the threshold for signatures for the initiated act is lower. It's about 72,000 instead of 90,000 signatures, but all the signatures will be gathered together, and I have to believe that if people vote for one, they'll vote for the other, and the other way around as well.
I want to bounce back and forth between you because I don't need repetition on this one. One of the things it's going to do is define a public meeting. Why does that need to be defined, Jen?
Well, right now, it's unclear if two members of a city council or of a quorum court or another board get together and talk about official business, whether or not that's a meeting. And our elected officials deserve that clarity because many of them want to do the right thing and want to follow the law, but they're not sure what it is. And then our people deserve that clarity because we deserve to be there when we make those decisions about official business. And so it's really crucial to us to get the language right so that we allow government to continue to do its job and spend our money wisely while also making sure we're allowed to be in the room when they do it.
Stiffens the penalties for violators of FOI. I mean, do I need to be, am I looking at jail time? I mean, what's the deal?
I'll call the prosecutor on you, Roby. No, so the criminal penalties right now the same. We are hearing a lot of feedback on that, but the criminal penalties unchanged. It does create a civil penalty. And what we're really looking to do are the egregious cases where people know they're violating FOIA and they really do it on purpose. And so it's just an incentive not to do that.
Keeps attorney fees intact. Why? That has been attempted to be stricken out, and there's been a lot of talk about that. Why did we need to keep the attorney fees in there? How does that protect citizens?
Yeah, so right now the only way to enforce FOIA is to hire a lawyer and to go in and come after them. And most people can't afford to do that. And we need to allow them to recover that money so that we can police these actions. But we also agree and are looking at and hearing a lot of feedback about this idea that citizens themselves should have some access without attorneys, and we're working through that and thinking on that concept right now.
All right, substituting a new exemption for records related to security services provided to the governor and other state officials. This was a change that came about in this special session. You guys want to change it back. Tell me why. What's the rationale for that?
So this is a point that's under discussion, and I think will be a bit different when our second draft comes out. I think ultimately where we're going to land is, as everyone has always said, we want to be deferential to the security of elected officials, especially officials who receive threats. But those records don't need to stay confidential permanently. And after a certain period of time passes, it ought to be presumed that they're public. And so that's really the significant change. The way we have it in the draft right now is after 90 days, all records related to security are presumed to be public and should be subject to disclosure. And the other significant change there is that if the custodian, which is the term for a government official who wants to keep the record private, if the custodian wants to keep the record private, they're the ones that have to go to court. At that point, the burden is on them to go to court and say, hey, we need to keep this confidential to maintain security for, this particular particular reason, and the burden is on them to prove that to the court.
All right. Go ahead. I'm sorry.
I just want to say one other thing on the public meeting, because we are getting a lot of questions about this. It's probably the issue we spent the most time on, and it is very important. I don't think we're going to be creating really a huge amount of new law, Roby, on this. We're really just codifying a lot of what the Supreme Court has done over the years, but not everyone reads Supreme Court opinions, and that's why it needs to be clear in code for both elected officials and the public, as Jen said.
I got 30 seconds left. What are next steps? What happens next? More town halls? Or are you ready to start collecting? Or you got to get the AG's approval on this?
Well, we've got to get the draft ready first. I mean, the draft's not ready today, and we're still working on that. Once the draft is ready, then we'll get our ballot title and we'll submit it to the AG. But I'm serving 3 million Arkansans right now. That's my client, and so
how much do they pay? Are they paying pretty good?
They do not pay well.
Just a penny per person would be all right.
Right.
Yeah.
But they have a lot of input and feedback, and so we are not going to stop listening to the public and working to incorporate their knowledge and experience in this until we have no other choice, until the ballot title has to be there and it's ready. But right now, we're really working on a way to make this last and be a good, positive change for Arkansas.
Do you have more town halls coming up? Or are you through?
There are, and I know we will have more when our second draft is released. I think right now we've gotten a lot of feedback, and the ball is in our court to release a second draft, and that'll be coming out soon.
Yeah.
What do you anticipate any problems with the AG? Or having conversations with the AG's office?
We haven't had any conversations with the AG's office. David Couch, who's on our committee, has been working on ballot initiatives and measures for years, and he said he's never gotten one approved on the first run, and that's part of the process, and we'll just see how it goes. But we're not doing anything to prep the AG's office at this point.
And I know a question that came up at one of the town halls is who's going to back you guys financially on this? And I thought that was an interesting response that you got out of that. I'll pose the question and see if you can replicate that answer. Who's going to underwrite this? It's going to cost a lot to get this on the ballot and to promote passage of it.
I think everyone will. I mean, I know that sounds very Pollyanna, but I really do think that we are making progress on a draft that serves all interests in Arkansas. And I'm not worried about it.
Yeah, and I don't know. I mean, my job really is to help.
It's a great role for a chairman right there to not know where the money's coming from.
So I'm chair of the drafting committee, so there's going to be different groups. This group right now is trying to get the language right, and that's what my focus is and what I'm working on. And Nate Bell, who's really kind of the leader of the whole coalition, he's got his hand in every pot, and I think he's going to be the one leading the charge to try to raise the money for the legal challenge and whatnot. I don't think I'm going to be on that committee, but we'll see what happens.
You raised a lot of money when you ran for Congress that one time. They may want to tap into that donor base there.
Yeah.
Who do you anticipate will oppose you on this? Do you anticipate opposition from Governor Sanders, from the Republican Party, from any particular group? We've got about 30 seconds on that. Anybody want to speculate?
If we get our draft right, I don't think we'll have meaningful opposition. And we're in the process of changing a few things based on the input that we've gotten from the public and from public officials. And I'm very hopeful that we're going to get it to a point where there's not going to be major opposition.